We're joined by Mr. MS Sahoo, the chairman of the IBBI. Mr. Sahoo, you in this insolvency conference that is organized by CII, you pointed out many challenges which are facing the insolvency and bankruptcy code at this point in time. Also, the stakeholders. You pointed out some of the things that the IBC is not expected to do. Is it that there is a lack of understanding within the stakeholder as to what the IBC aims to achieve?
This is absolutely new law. Everybody is on the learning curve. When we started in 2016, we did not have an IP, we did not have a committee of creditors, did not have adjudicating authority, IBBI. Everybody is doing this work for the first time, and therefore it is natural that we take a little time to understand the real essence. For example, there is always a debate whether it is a law for recovery or resolution. It is in the very preamble, it states that it is a law for insolvency resolution. But that does not mean that while doing resolution, one cannot recover. But recovery cannot be the prime objective. So we must realize that this law, this process is intended to rescue a viable but failing business, and not that we focus only on the recovery, because as I told, recovery leads a firm to death, while resolution is to rescue the company. We should not be focused on recovery. We must be focused on the resolution, but while doing resolution, we do not rule out the possibility of recovery. So this understanding is important, that it is for resolution, it is not for liquidation. There can be liquidation, business may not be viable, but you must first try, make best possible effort to rescue the company. Only when you fail to do that, go for liquidation. The liquidation cannot be the first option.
Right. Another question that was brought up, and this was something that Mr. Shadowshov pointed out, is the lack of takeoff in the information utility side of the business, because that is an important cog in the wheel whenever we're talking about insolvency. How soon are we likely to see an information utility becoming the norm in insolvency cases across the country?
See, in this law, there are two sets of participants. One is the authorities comprising the government, adjudicating authority, IBBI. I include in that category also insolvency professionals. The other category is market side. These are the committee of creditors, resolution applicants, information utility. So from the state side, over which state has control, all these have taken off. Market works on incentives. Market waits for right opportunities. You know, we started something called depositories in 1995. We had a law in 1995. But it didn't take up actually till 2001. So market has a gestation period. Information utility is a market mechanism. We have to allow some reasonable time for information utility to take up.
Right. Another question, and we'll be remiss if we do not ask this, is the extension of timelines whenever we're talking about some of the large cases that are being resolved at this point in time. Do you think that this extension would soon become a norm? Because 270 days is probably too short a period for a resolution to fully be implemented?
The first is that, as you rightly mentioned, in the large cases, there has been extension of time. That means in most of the cases, in terms of numbers, say we have 1,000 companies admitted into this process. So most of the cases do not require extension of time. In fact, the law envisages a fast-track mechanism in 90 days for a still smaller set of companies. But as we are doing something for the first time, new issues have to be sorted out. And it is natural that the court follows the due process to sort them out. It happens in a few cases, but I don't think in the long run, once the issues are sorted out, if you observe, when we started the process at the admission stage, there was undue delay because certain issues relating to admission were to sort it out. Now that all these have been sorted out and stabilized even up to Supreme Court, say for example, the extent of principles of natural justice to be followed, whether the existence of a dispute is adequate or the dispute should have substance. So all those matters have been sorted out. Now admission process has become fairly simple, In fact, Mr. Shroff was just mentioning that the admission process can be made mechanical, can be templated. There can be a template for financial creditors where the process of admission can be almost swift, instantaneous. So we have to think of finding out innovative ways of making things happen. I'm sure at the approval stage it is taking a little time. In course of time, the route would be clear, the process would be faster. These are all initial problems.